Hello. Looks
We're
like
back on the record, case number 2020 CF
like we're back at it.
2603,
Let's
State of
do this
Florida
thing.
versus Sarah Boone. Let me get appearances for the state.
Steve Castro on behalf of the state. William Jenkins, state.
Defense.
James Owens for Sarah Boone. Tony Henderson, Sarah Boone. Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. She is in custody. However, there are no restraints as she will be standing as with the rest of us when our jury enters and exits. It's 12:57. State, anything we need to address?
No, sir.
Defense.
Judge, I've got something. Can we approach the bench?
Yes.
All right. We are doing this thing, huh?
He's a lumberjack and he's okay. He sleeps all night and he works all day.
Yeah, so thanks to the break. I actually got to bust out of my cave for 5 minutes, and I rolled over to Lincoln Park, as is my habit, because I live right next to it. And now I'm feeling the fall vibes. It's happening in Chicago. The leaves are changing. There's the deep insight you were looking for. Now back to the trial.
There shall not be any cutting of trees. Don't cut any trees. I'll pass the order. No cutting of trees, no felling of trees in Patna number 12.
Yes, Yesenia. I went for a walk. I called you, but you didn't pick up. Oh yeah, we did the airing of the grievances yesterday. We're doing the law offices of Michael Graveline airing of the grievances right now. It's not all sunshine and rainbows. Oh no. Basically, yeah. I think that about covers it. Yeah. Where's my picture? Let me see if I can find it.
Has been recognized by the Florida Supreme Court.
This picture's a fraud.
Approach.
Oh my God, we're back. I can only bust on Yesenia for so long. Yeah, whatever. She knows all about it. Chicks. All right. I'm just kidding. We need a little something to erase that memory.
And I hate, God, I hate this. He's on what's a dick pussy, dick pussy, dick pussy, dick pussy, going back and forth between texts with one another, and I never want to hear it again.
To be here at 1:30 for her testimony.
Yes, sir.
Just 1 second, sir. Thank you. I'm waiting for Mr. Owens to return.
Seriously? Ben Bateman in the house.
Appreciate it. Thank you, sir.
Judge, may we approach him?
Without Mr. Owens?
Yes, sir.
Sure.
Oscar says hit like and subscribe. Well, and hit the bell notification. Thanks, Oscar. I always think of that.
having the charging conference regarding the jury instructions at this time. That will be conducted tomorrow. I have requested the defense to provide any instructions that they are seeking to be provided to the court and to the state in Word format tomorrow, including but not limited to 3.6F or 3.6G and any portions thereof that the defense is seeking to utilize for the purposes of jury instructions. The court throughout the trial has been redlining the jury instructions that were provided initially by the state. At the end of the evidence and testimony presentation this afternoon, the court will email those to all parties. Once Mr. Owens comes back in from advising witnesses of when to be here, we will bring in our jury and proceed with the evidence presentation this afternoon. State, anything else we need to address? Defense, anything else we need to address?
No, you
All
are.
right, very good. As soon as Mr. Owens enters, we'll bring in our jury. The deputies will assist Ms. Walker in the wheelchair into the jury box.
I've called her 3 times. I did text her. I don't know if she's in the process of switching around.
Oh, yes.
Back on the record, and Rodolfo Villarreal.
Reader
Mr.
bot
Regier?
3000 in the house.
Your Honor, at this time, I have not been able to successfully view the ticket in this case, so the state would be requesting a copy of that ticket from the court clerk's office. Under these circumstances, if the court is prepared to set this matter over briefly, the state would not have an objection.
Stacy, do you have a date in the near future we can set this first appearance over for rather than setting it in February?
Give me just a moment, okay?
Sure.
Oh, man, I gotta get together.
Of course, you'll need time to issue a summons. Is that what you're planning to do, counsel?
Your Honor, if the court is prepared to proceed by a summons in this matter, the state would not have an objection.
Okay. So how long would you?
That's personal time.
Appropriate date.
That's work time.
Again, as I am requesting a copy of the ticket in this case, I do not believe I am in a position to make many recommendations at this time.
Well, the ticket did order that he appear today, but if you issue, you're going to need time to get the ticket, study it,
That is the state's request, Your Honor.
file a summons. The sheriff's going to need time to serve it. Let's see, the defendant's address. Iowa. Well, Stacy, maybe we ought to just go with that February 12th.
The 22nd.
Was it the 22nd or 19th?
The 22nd. Oh, no, you're right, the 19th. Sorry.
Finally, I'm right. Fine, yay. Okay, February 19th, 9 a.m., Mr. Regier, and if you want to issue that summons, that's how we'll handle that.
Thank you, Your Honor.
All right, thank you all. We'll be in recess on that case. We'll now be on the record in 2024 TR 1991, State of Kansas versus Chandra Gale Young. Jared Regier appearing for the state, Ms. Young failing to appear. Appear on no registration, no insurance. Ticket issued. Citation and notice to appear. for today's date. And defendant fails to appear. So she was given notice of the hearing by the officer. Recommendations, Mr. Regier?
Your Honor, in light of the notice to appear date on the ticket as well as the charges currently
That's for
before the
Maria and
court,
Iris.
bench warrant 1,000 cash or surety is the state's recommendation.
Bench warrant will be issued, bond will be set at 1,000, cash or surety required. Believe that's everybody on the docket. Anyone have anyone else?
One moment, Your Honor.
All right, sir. All right, what I want to do is.
Mason's
review
usually a
the,
hotbed of
group
stupidity.
Advisory rights that I explained to you. Have that paper by chance? Oh, never mind. Nope, that's 2 copies. I don't have the rights.
I call her over.
When I see her walking with a dog and I see her and I look at her and I said, "Hey, Sarah, how you doing?" And that's it.
And would she generally respond to you?
Why didn't anybody tell
Yes.
me?
And how, well, no, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes,
How long would you speak with her?
about 15 or 20 minutes. That's all.
And was your husband sometimes involved in those conversations as well?
You just say hi.
So you and Ms. Boone were the 2 primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. Have a mark on her arm. And I just asked her.
And would she describe how that happened?
Just say, I had a,
Hang on. Understand. The objection is sustained.
Objection. She has to testify to that. Come on. I mean, they made the objection.
When you would ask her that, how did she appear to you to respond emotionally to your questions about her injuries?
she just say, one of them days or something.
Objection sustained.
Just for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I would see the emotion that she was upset about something.
And did you ask about her obvious upset persona? Her upset, the fact that she was upset? Would you ask her about that?
Yeah, well,
Okay, you have to just limit your answer to the question. Would you ask her about that issue? About why she was upset?
yeah.
Okay. And I'm sorry, I just can't go beyond that. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
Was that primarily when you saw her on the weekends?
Mostly I would see her walking through, going to her place. And when I'm sitting on the porch and I see her then.
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No,
How long have you been gone from that apartment complex? If you don't know, that's fine.
It's been a
Thank you, ma'am. During the occasions that you had to interact with Ms. Boone, how did she treat you?
She was a nice lady,
Overruled.
nice to me.
Did she ever act uppity?
Objection. Relevance.
Overruled.
Did she ever treat you in an uppity manner?
What you mean, sir?
Did she ever look down on you as a person?
Oh, no,
Did she ever treat you with disrespect?
no.
I'm going to object. This is character.
Sustained.
May I approach on this, Your Honor?
Yes.
Yeah, this is getting sleazy. Yeah. Yeah. The attorney's baiting her. I'll let you connect the dots. It's kind of disgusting. But that's where we are. That's understandable.
Objection sustained.
I'm sorry, I'm back, Mrs. Walker. In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, Were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No, I can't say.
Did you also observe George Torres during the time that you lived together, lived there in the apartment complex?
I didn't see him very much. If we sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Yeah, that's a great series of questions. He's saying if you didn't know she was drunk, you
Was
don't
there
know
an
her at all.
incident when you saw
That's the
Ms. Boone
implication.
with a black eye?
And it's good.
Yes.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yeah.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay. Did Ms. Boone complain to you about those marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Oh,
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there because we always sit out there.
Right, but we don't
Okay,
know
what
if this
day?
is December or 2018 or
I
anything like
can't
that.
remember, sir.
Okay. And is it fair to say
Of course
you
you
have
don't
no
know.
idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
Do you know where you are? Do you know who the president of the United States is?
On the weekends, I see him and her
Do you know what
going.
day of the week it is?
But you don't know who, if anybody, put those marks on her, right?
Well,
Just calls for
I
yes or
can
no.
tell when they must have had an argument or something. I hear the dogs barking.
And you're 5 doors down, right? Unit 8, Unit 3?
Yeah.
No other questions?
Any redirect examination?
No, Your Honor. Thank you.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am. Ms. Walker, the deputies are going to come get you and take you out, okay?
You all done?
Yes, ma'am. Thank you so much.
They've got the morphine drip. Don't worry. All right. So they unearthed a person that wouldn't exactly say she's friends, but could stand the defendant. Great success. She doesn't know anything. She's a sweet old lady. She's a sweet old lady who is neighborly to the neighbors. That's it. She didn't get enough contact to really get irritated by her. That's all we know. If she'd spent 10 more minutes with her, she'd hate her. Oh, good Lord.
Defense ready to call your next witness.
Pearl rocks.
Yes.
Now, you didn't say the cat jumped on his wiener, did you?
Yes.
He was dry humping all that, dude.
Oh my God.
Yeah, that's what I was saying. He was getting after it when I pulled up.
All right, members of the jury, witness is running a couple minutes late. I think they may be stuck in the security line downstairs. So we're just going to be in a short recess for them to join us this afternoon. Similar instruction that I've given you, please do not conduct any independent investigation or research regarding the person, places, things, or charge involved. Do not have any discussions amongst yourselves or anyone else, and we'll bring you back in as soon as that witness arrives. Thank you again for your patience. Y'all can be seated. Thank you. We'll be off the record until Dr. Harper arrives.
I would like to hear that you got permits and you're living it by January. But let's see. So that'll be enough time to give you get the roof fixed, which you got to do whether I tell you to do it or not. Otherwise, your house is going to fall down. Then we'll worry about the electrical. Okay. Do you have any questions?
No, sir.
All right. January 15th.
Your Honor, is she having trouble with the contractor, or is she just having the financial issue with it?
The roofing contractor?
Yes.
No, my brother wanted to save money and he just thought he could do it and I told him no.
So is the roofing contractor is willing to complete the job?
Yes, he is. Luke is willing to come back.
Okay.
All right. Somebody tell me when the
All
trailer
right,
comes
very
back
good.
on.
So once again, do you have any questions? All right, I'll see you in January. By that time, I hope you got a roof over your head.
Thank you all very much.
Okay.
Thank you, Jody. Thank you, Your Honor.
Mr. Clement.
Thank you. All right, Ms. Geschwind, I'll see you next time. Same for you, Doug. Thank you.
Judge, do you need an order on this?
Yes, just do an order.
All right, I've got the roof fixed by January 15th, $120 in cash by Friday. And then I'd like to add a provision there that Doug or Mr. Coleman be allowed to enter the property. It sounds like maybe there was some emotion issues and they didn't.
Yes, you can put that in there.
All right, we're waiting on someone from the plaintiff to appear, presumably remotely. Give me 1 second. Sprague, I see something on my docket.
Come on, Judge, I got a stream going
Doesn't
here.
have a defendant. I don't know if that was taken off the docket. Let me see. Application number, it's
Should have, there should be 4 cases, Your Honor.
yes, let me see, 240661 LT. This one is Lejeune Munson. Has that been disposed? Lejeune Munson case dismissed.
I do not have that in front of me. I can look into the matter. You said it was Lejeune?
Yeah, Lejeune Munson. I see notice to dismiss.
2024 at 9:00 a.m. The second paper just talks to you about the 3 outcomes that I discussed within the group advisory.
Okay.
That's for you to have, and you're all set.
If I happen to have to move to another show to.
Trying to find something.
Am I allowed to do by phone or do I have to come back here?
You have to, if you wish to do that by phone, you'll have to submit a request to do it telephonically because it depends on where you'll be located. And you don't need to say the exact, you can just tell us the city.
Okay.
To take that into consideration. Okay.
He found me in 2 different locations and so.
Yeah. So if that occurs, and so that's why the 2 pieces of information, we'll try to prioritize it by email. Do you check and use that?
Yes.
Okay, so we'll do that and may probably use the phone.
Okay.
Okay?
Okay.
All right.
Thank you.
You bet.
Quentin?
Hello there, sir. How are you?
I'm fine, Your Honor. How are you?
I'm doing good, thank you. Give you a chance to review this case here. So, all right, this is case 2010 CR 467. This is a violation of under 21 with alcohol in your body. 2010 case. Has some age on it.
It's dated a while back. I was incarcerated in the Department of Corrections, and I had submitted a motion to quash, and I guess that motion was submitted because they lowered my points down when I was in DLC.
Okay.
And I figured it was taken care of after that.
Okay.
Because then my points had dropped and then the retainer was dropped. But then recently I just discovered that I still had a warrant out for my arrest.
Understood.
Which is why I'm here today.
Okay, all right. So we'll try to get it resolved today for you. So were you here in the group advisory?
Yes, sir.
That allegation, I believe, is a class 1 misdemeanor and does not have any jail time asked of it.
Okay.
Do you have any questions about the court appointed
no.
attorney? Okay. And then if you would date and sign where it's highlighted.
23rd today.
Correct. Thank you.
Do you guys have arraignments?
Do you have an arraignment?
No, but just a quick question about your trial schedule. What time are you starting? What time are you breaking? I've got the only reason I asked.
I'll do get your plea ready. I'll do it now.
It's a Spanish plea, so okay.
Okay, get it ready. Rock and roll.
Okay, case 7, Fairly, come on up.
Are you Dewan Fairley? Mr. Fairley, you're charged with assault of a family member. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Any witness and the defendant are dating and they have a child. On October 14th, 2024, any witness was driving while the defendant was a passenger and their son was in the rear seat. Defendant began questioning complaining witness because he thought she was cheating, which prompted an argument. Defendant began putting his hands in complaining witness's face, impairing complainant's ability to see the road. Complainant brought the vehicle to an immediate stop. Defendant then began grabbing her left shoulder. While defendant was grabbing her shoulder, complaining witness turned and bit defendant on his hands.
Which is
in an
number
attempt to
one.
get defendant to
Wrong.
release her. Defendant then punched complainant with a closed fist in the face, causing pain.
All right, Mr. Fairley, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with them? Morgan?
I believe she does.
Thank you.
It can be looked at unless there is a knowing intelligent waiver, and that stuff's going to be put out to the public for consumption. So I'm going to ask you as best as possible not to view, take pictures of, or look at any of the laptops, be it the defense's laptops or the state's laptops, to avoid that. With regard to the camera, if we can, when zooming in on either the defense counsel's table or the state's counsel's table, if we can try to avoid their laptops, I would greatly appreciate you, sir. And the podium. Thank you. All right, we are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Castro on behalf of the state.
Defense.
James Owens on behalf of Ms. Boone.
Tony Henderson for Ms. Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse. Let's go ahead and bring in our jury as Dr. Harper is here.
Rise, jury's in.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury. All right, thank you. All could be seated. Again, members of the jury, if you could, just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time, you may call your next witness.
We call Dr. Julie Harper.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington. As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is a community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working during the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments, to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice, because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just quieted down, of course, from COVID, and I was not in full-time practice. So I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the panhandle of Florida.
And is that where your practice is currently?
Yes.
All right. Is it fair to say you travel the state to?
Bless you.
Is it fair to say you travel the state to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then of course working along.
Is it fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right. And when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
You said that your practice is now entirely forensic?
That's correct.
What you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing hearings. I've been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert, in what's called social investigation. That's what they used to call custody evaluations. So in numerous capacities.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide, and you're paid by the state.
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would, need a psychological expert to explain something to them.
Ma'am, are you a whore?
I also do fitness for
I object to the relevance of that, Your Honor.
employment evaluations for law enforcement
Right.
and
What-
firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you're going to have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person, or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution.
Yes.
And you've testified for the defense.
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Are there times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Miss Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Ms. Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have been.
How many times did you meet with Sarah Boone?
So 9 times.
All right. Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Well, we had a clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay. So you considered some medical records?
Yes.
And did you also consider some records from George Torres's records?
I did see his hospital records.
Now, do you consider in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with.
Roach. The objection is sustained.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Sustained.
You considered the entire family background and history without going into the details of what she said or what you learned from looking at records? I'm sorry?
Yes.
And did you consider her relationship with her mother as part of her psychological development?
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was
Oh my
evidence
God,
that she had
English.
low self-esteem, and her coping mechanism was to identify what made her stand out.
My
And that
coping
would be
mechanism for this is gonna
consistent
be
with a
scotch.
narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
Now, Dr. Brannon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that from this manual in your studies, in your experience, where they require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder
Compound and leading.
related
What
to
I'm,
that.
what I'm getting to is many times you may have these narcissistic traits, but really you suffer from.
Seriously, object to this.
That's
it'll
the
take
underpinning
longer.
of that criterion.
Would you explain that to me?
If I'm allowed to reference the DSM, then I can explain it best.
Oh, boy.
Just don't read.
Oh, here we
from it.
go. This ought
All
to be
right.
fantastic.
You need to read a paragraph.
The first
and
explanation was,
explain it to the jury.
yeah, she's a narcissist, but in a good way.
So
That was
based on the
answer to question one.
description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities because at root, they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that?
Okay. Asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Or the criteria?
there are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder.
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her with narcissism, that disorder.
That's correct, because the DSM's description guided me that would not be an appropriate
I was guided by the
diagnosis.
DSM.
Why did you not diagnose Ms. Bing with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, settings that she has these symptoms And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Mm-hmm. So if you have trauma, you
Have
can't be a
diagnosed her
narcissist.
With anything, and we'll elaborate
Oh.
on that, but through your assessment,
Please.
have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder.
Yeah.
She has
We're all gonna have it too
symptoms
after
of
this.
anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And
Ma'am,
feel
are you a
like she
whore?
Suffers from post-traumatic stress?
I do.
Now, at the time of this incident, this event, we're talking February 23rd of 2020, you were aware that she did not have much family support.
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help assist me in making sure that the person is intending to put in good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type of thing?
Right. And so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller Forensic Assessment of Symptoms test is.
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms that would be unusual or not typical of a valid psychiatric patient.
What were the results of Ms. Boone's test on the Miller Forensic?
She validly participated. There was no indication of any feigning or malingering.
And as far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff that would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
At the time that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
or tell me the results. Just
yes. So the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test. That wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms, that was consistent with the outcome of that test.
And would this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma
Bless you.
to after the alleged trauma? And I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from a trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to
No.
make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in the arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes,
Did you consider the previous diagnoses in arriving at your own?
I did. Yes.
What did Ms. Boone, what had she been diagnosed with prior to you getting involved?
Roach.
This today, Your Honor, my health is in jeopardy right now.
What's up?
I have IBS, irritable bowel syndrome,
Mm-hmm.
and what's been going on,
Very stressful.
I'm bleeding inside, ma'am.
The objection is sustained.
But you would agree, and I think this is a fair question, you would consider prior other experts who may have diagnosed her with something?
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time when I diagnosed her myself.
And given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder, it's my opinion at the time of the offense, she had depression and she had an alcohol use disorder.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely.
Sustained.
You have viewed. Have you viewed some exhibits involving her being stabbed?
You think George has post-traumatic stress disorder?
I think that we have
I mean, if he was alive.
exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Overruled.
Just generally, without getting specific, I think I've explained post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping. So their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all
They
features.
have trouble sleeping sometimes.
Yes.
So it's a response to a stimulus in the environment.
Is a real issue.
It's associated with
definition,
things like
everybody has
nightmares and having trouble settling.
Every day.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
If you voluntarily drink
Alcoholism
Woodbridge,
can be,
you've got an issue.
depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in diagnosing.
Yes.
The many people who suffer from alcohol use disorder, I don't know how to put this, are they in denial?
I would say that that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have a problem.
That's right.
What is the difference between traits and a diagnosis?
Well, we all have personalities. And so you're going to have coping mechanisms that include personality styles. So for instance, Even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like. And that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across like all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes. So the diagnosable condition would be PTSD or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware that that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case?
Yes.
In a criminal context.
Yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because of course they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
Just briefly touch on, because I know Dr. Brandon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event. So something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's like called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim that's getting abused, you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone, or some small behavior that might not mean much to another person, but it has preceded other violent acts. So for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home. And that could be a signal, like abuse and violence has occurred in his stay-at-home clothes. For instance, that might not mean much to another person because, again, it's specific to that dyad. Those two people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hypervigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you've diagnosed Sarah Boone with. When those personality changes occur and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change, like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of, scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
And it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur.
Yes.
When a threat was about to occur.
Yes.
A threat of danger.
That's right.
Now I want to talk about placating the abuser. A victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal, in which the battered woman may attempt to reduce through several different means to delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. It doesn't always stop it.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's a strain, sharper words come out. I think that that is the way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation?
Yes.
Suicidal thoughts?
Yes.
Substance abuse?
Yes.
And there are often physical signs of injury such as bruising?
That's correct.
Chronic fatigue?
Yes.
Learned helplessness?
Yes.
Can you tell I know Dr. Brandon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked. And the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference. So don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that one of the conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where like in the alcoholism where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on. And it seems like denial. In other words, your coworkers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them?
Yes.
And they're numbing their emotions to it.
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it because numbing it means that you can keep that relatedness no matter how bad it's getting.
Do some people with this syndrome disassociate?
Relevance. Approach. Objection to relevance is overruled.
Do you agree that battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience?
Some people do experience that.
I'm just going to list some of the symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance,
Yes.
the panic attacks,
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
very low self-esteem,
Yes.
poor body image,
Sometimes.
feeling that they have no control,
Yes.
sexual dysfunction,
It can be, particularly if the trauma includes sexualized attacks.
short-term memory problems and confusion,
Yes, that's part of PTSD sometimes.
and they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
Fear,
Yes,
constant fear.
that's correct.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
Approach. You may proceed, sir.
All right, I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting,
Yes, that could be an overt act.
kicking,
Yes,
punching,
yes,
choking,
yes,
burning,
yes,
using weapons to hurt you,
yes,
a knife,
correct.
curtain rod,
Yes,
threatening to hurt you, your children, or your pets,
yes,
belittling and humiliating you,
that's correct.
taking your car keys,
That would be considered a form of control. So yes,
controlling your money,
yes,
control where you go and who you see
correct.
and who you can talk to,
That's right.
force you to have sex when you don't want to,
Yes,
Stalking you,
Yes.
slapping you,
Correct.
you agree victims that suffer from this abuse experience feelings of anger,
Yes, that can be in some of the phases. So,
sadness,
yes.
hopelessness,
Yes.
worthlessness,
Correct.
intense feelings of fear.
Yes.
Abusers have a tendency to have low self-esteem themselves.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself,
Yes.
have a desire for power and control,
Correct.
have a tendency to use alcohol or drugs.
Yes.
Abusers oftentimes have temper,
That's correct.
become jealous easily,
Yes.
very possessive.
Can be.
The victims can suffer from severe psychological distress.
That's correct.
Is that what Sarah Boone suffered from?
Yes.
Yes, sir.
Dr. Harper, I'm showing you Exhibit 14, this is 5 photographs. Did you watch the video of the TV, the Baton TV?
I did.
You considered that in your analysis and your diagnosis?
Yes, I did.
I'm going to show you some pictures. Exhibit 12. I believe she's testified that this is where the curve line. Are you familiar with that?
Yes.
Exhibit 11. Are you familiar with this photograph over here?
Yes.
Exhibit 10, which is her arm. Are you familiar with that photograph? Exhibit 9, picture of the bloody knee. Exhibit 8, picture of her black eye.
Yes, I've seen these.
Picture, exhibit 7, picture of her, Sarah's lips and it's like her eyebrow.
Yes.
And this is a composite exhibit 6, which is of the stab to her leg. Are you familiar with those?
Yes.
And I don't know if you've seen this exhibit 5 is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen the medical record associated with that.
Of that burn. Exhibit 4.
Yes.
Okay with that? Looks like exhibit 3. She was slapped.
Yes.
Exhibit 2. Picture of bruising in this book.
Yes.
Did you consider all those photographs informing your opinions that you've expressed here today as it relates to Sarah Boone?
Yes, under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times, to visit with someone like this to build trust?
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times they're very slow to open up and tell you about the abuse.
That is correct.
And they'll actually often lie about it.
Deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's a result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and given to this?
Yes.
That's all the questions I have.
Any cross-examination?
Yes, sir. Good afternoon, Dr. Harper.
Good afternoon.
So you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert, yes.
No, man, what I'm talking about is you just went through that you had 9 visits with Ms. Boone.
I did, yes.
And that was over the course of 8 different days because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get one crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right. Specifically, when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the issue? Oh,
Judge, the question.
Legal objection.
Objection.
Legal grounds.
He asked a question about battered spouse and
Approach.
insanity.
Objection sustained.
When it comes to an affirmative defense such as battered spouse syndrome being used for self-defense or, not and, insanity, it requires a court order for the state to go have an evaluator go, right?
yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response like a mental disorder. So first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth?
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth, correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic.
They could.
Or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual by an intimate partner as well, correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, I guess, cues for that person and also working with law enforcement, they become seasoned to micro traumas. So almost every police officer can remember the first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, that's not what I said.
I'm not saying you did.
Okay.
What this battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping, I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally it was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things, why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach. Check. Question withdrawn. You may proceed.
All right. So you would agree that hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Propping one up, hypothetically saying, I'm the best thing that has ever happened to you. You'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of a potential exertion of control over an intimate partner when you give somebody hypothetically a bike, but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Now I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit. Okay. Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase, you would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her.
Correct.
And she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different hypothetically than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's right.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father, correct?
Right.
A better ex-husband.
With phone calls. Yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia or indicators, sorry.
Understand.
I know you know. That perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that, like make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, you know, she was low 40s when she met you 4
Yes.
years ago?
That's right.
So she had been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
You said for 24 years. That's why I was confused. You can't be 18 for 24 years, but
Did
24 years ago, I would agree.
Did her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband, was lump sum plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
It was Mr. Torres who would work, correct?
He worked at Ace Hardware, I think.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
and that her child had gone to school and reported it, correct?
Yes,
And you understand as a forensic psychologist that teachers are mandatory reporters, right?
that's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Miss Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes,
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
that's right.
And February 24th of 2020, the child was scheduled to be picked up by Miss Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes.
Object.
Roach. Objection sustained.
Or phrase it. She swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That
I object.
Roach. Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's quote unquote swore on her child's life that it was not intentional. That, correct?
before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you. It's on video. Some of Miss Boone's diagnoses predated her relationship with Mr. Torres, correct?
Yes.
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon we see, correct?
Well, I wouldn't say that all mental disorders have an independent cause.
Okay.
Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had these.
Also, yes or no, ma'am?
Yes, she did.
Thank you. You reviewed some Advent health records, correct, of hers?
Yes.
And some Aspire records of hers, correct?
Yes.
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
Yes.
And there is a time when she goes to the hospital where she is described, their words, not mine, as having ETOH on board.
Yes.
Do you understand what ETOH means?
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes.
Drinking alcohol, not the other stuff.
Correct.
And in the records that you reviewed from Aspire, she came with complaints of depression in January of 2018, correct?
That's right.
And ethanol or alcohol is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist. So let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
Generally, yes,
And you can and do make diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking? For instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you familiar in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like I try to identify that.
And do you ever ask if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
And in January of 2018, when she came in crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165, correct?
I believe so.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
So there have been 2 sets of records, but I believe you may have the same set that I received on September 27th, 24. Can you turn to page 21 of 57 of the Aspire records?
mine aren't numbered, but I will.
May I approach the witness?
Yes.
All right, may I first look?
You may.
What I'm showing you is what is page 2157 on records from Aspire that was provided to me by the defense on September 27th, 2024. And just at the top, you can read the first or the 4th lines.
All right, Judge, I would ask that she be allowed to read that entire paragraph. Under the rule of completeness.
Approach.
Will it ever end? This case has actually been clipping along really well, and it's been pretty entertaining. It's been pretty good. But it's been a rough day for witnesses. Except Grandma Pearl. Grandma Pearl was cool. She didn't know anything. She just wanted to get back and have her Enfamil, you know? Her testimony is like, I lived in the same place for a while. We'd occasionally bump into each other, and we weren't openly at war. That's as far as I'm going to go.
You may proceed, Mr. J.
Thank you. All right, October of 2018, or of 2018, there was a second visit to Aspire, and that was based upon her being found stumbling by law enforcement with a .185, correct? And that's
She
supposed to be
walked
yes or no?
up. Okay. So I'd have to say no, the way you phrased the question.
Ma'am, Boone was stumbling due to her level of impairment, paren .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
Thank you.
She's got to get her glasses straightened out before I can even begin to take her
You
seriously.
talked to Ms. Boone about that.
I mean, don't get me wrong. I'm still not going to take her seriously.
June of 2018.
But it would help a little.
regarding those two events, did she not?
No, she told me she had two different Baker Acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
No. Do you remember giving a deposition on October 1st at the state attorney's office downstairs?
I do.
And at that point in time, and I'll ask opposing party, you want me to show her prior statement before I ask her about it?
I think she's got a deposition.
Do you have your transcript?
I do.
Just,
So for the record, it's page 34 that I'm referring to. Line 16 and 17.
Yes, I'm with you.
Okay. She described that as June of 2018.
That's what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes,
And ends up going to what we call Lakeside then and Aspire now, right?
yes.
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were two separate.
Oh, I can take this one.
January when she.
It's one of the joys of getting old.
Correct?
I wear glasses too, and I can't read with them on.
So I'm just
That
clarifying.
fun stage
there's
where
a
your eyes get
record
cleared up
that
both long
we
and
started
short.
with this conversation from October of 2018, and there is a description of her trying to go to the hospital to seek a counselor. So those are two different instances.
In January of 2018, when she went to the hospital crying and signs of depression.
Bless you.
She indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
exciting and new.
So the hospital records are not referencing her relationship with George on the January date.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
She indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
Those include photographs of Ms. Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp. So I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
And did you ask her
Okay, that being no.
who was dragging down the stairs?
I don't think I went through specific injuries to her. No.
Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you, patient or a client?
If they're actively intoxicated, yes.
We had talked, well, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
Are you you're talking about the criterion of narcissistic personality
Yes.
disorder? Yes.
Like page 761 on your hard copy?
Thank you. All right.
Was I close? I have a digital copy.
760, but
One of the criteria is has a grandiose sense of self-importance. For example, exaggerates achievements and talents, expects to be recognized as superior.
Check.
Without commensurate achievements, correct? Yes. 2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love. Correct?
Check.
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high status people, or institutions.
Check.
Correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criterion.
You got him there, honey.
4 requires excessive admiration. 5 has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations. Correct?
Yes.
Check.
6 is interpersonally exploitive, takes advantage of others to achieve his or her own ends. Correct?
Check. Checkity check.
Is interpersonally exploitative.
7 lacks empathy, is unwilling to recognize or identify with the feelings and needs of others. Correct?
Yes.
8
Check.
often envious of others or believes that others are envious of him or her. Correct?
Yes.
9
Check. Oh my
shows
God, she's
arrogant
betting
or
1,000.
haughty behaviors or attitudes.
Yes.
Now,
She excels at narcissism.
you believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of self-importance.
There are indications that she
Yeah, there
feels
are.
like that or has expressed that before.
That's a yes. Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love?
No,
You remember going to the state attorney's office on October 1st, 2024 and giving a deposition?
Yeah, but she's got the Uno reverse card.
Order here.
yes,
She's experienced prior trauma, so none of this it matters. Didn't you hear her BS coming in?
To page 89, lines 18 through 20. Let me know when you're ready. Are you ready?
yes,
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high status people, correct?
No,
Does not require excessive admiration, correct?
correct.
Does have a sense of entitlement?
Yes,
Exploitive?
correct. She is not.
And when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware if she's inconveniencing others.
So there was 3 of those traits, correct?
Yes,
Not 5, which would be required, correct? For a diagnosis of the personality disorder.
if that were the correct diagnosis, you would need 5.
All right. During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review
Okay.
were the text messages that were
Based
part
on
of the
that
phone
standard,
inspection of her phone device, correct?
There's
That's
a
right.
100% cheating rate, at least in the United States.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control,
That's about right.
jealousy, easily angered.
This could be, yes.
What other traits for just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent like life, job, money, things like that, that would be
Oh, please.
supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a
Yep.
physiological reaction in another person. So those could be additional descriptions.
Specifically, the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior.
You might have me.
Involving Mr. Torres and Ms. Boone.
The octogenarians.
Medical records for Mr. Torres.
It tails off a
That's
little
right.
bit.
The medical and Aspire records for Ms. Boone that we've discussed.
Yes,
Crime scene photos from the incident in February.
that's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving a suitcase
That's right.
and additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV.
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes.
One prior 911 call?
Yes.
Now, today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Is that recently?
No, there are photos included with the
The prior case packages?
case packages. Thank you. I'm not sure what to call it. So
That's fine.
All right.
All right, and did you review any body worn camera from those prior case packages?
no, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
The Farmer's Almanac. Let's go through that.
Are you speaking of documents?
I can make up some justifications on that.
that. Your 9 visits with Ms. Boone.
All right. Just checking with the
That's fine.
folders I prepared
just
for
wanna make
today.
What's all you on about?
I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Did you interview anybody else personally besides Ms. Boone?
Yes.
Yes.
Who else did you personally interview?
We could do an
Melissa
astrological
Sexton.
reading.
All right, anybody else?
No,
It'd be
You
just
didn't
as
interview Brian
effective.
Boone, correct?
I did not.
You did not interview their child in common, correct?
No.
She can't be responsible. She's a Gemini.
You didn't review the phone text messages extracted from her device, correct?
No, I didn't.
Did you review any records from the jail?
No.
And
Judge.
Yes.
Are we done? Is it over? Is that it? Oh, sidebar. Yeah, now I can't read. There you go. There's some glasses. Does that satisfy your nerd fetish right there, everybody? Would it help if I put some tape on there? I cannot see anything now. Now I can see. Now, if I'm driving, I have to have those on. This is fascinating. This is fascinating. All right. Special for Kelly here. Let's do it. Let's do it. This is all her fault. Yeah, kick it off the bong hit. Kelly's a naughty girl.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
You're not a whore? Not a whore? You're not a whore?
There's a link to this
It gets worse.
on Bandcamp. I didn't make this song. Kelly did. She's the one associated with Bandcamp.
Ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
She also has lots of stories from band camp. Some are sad, some are happy.
Can you just let this go for once? For once? Once? Okay, that being no.
Mr. Sharps. Not a whore. Mr. Sharps. Mr. Sharps. Mr. Sharps. Everybody fucking dance. You're not a whore. You're not a whore.
I never want to hear it again.
You're not a whore. You're not a whore.
I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong.
Yes, but you can always have a kook. I think the prosecution's doing a great job, but that doesn't mean you don't get some blue-haired freak on the jury to just go, oh, man loses because reasons.
Ma'am, are you a whore? You're not a whore? Not a whore?
Usually, I don't know. You can have a non-unanimous verdicts, but usually not in criminal cases. I'm guessing Florida requires unanimous for a criminal case.
The objection is sustained in part and overruled
Thank
in
you.
part.
You testified earlier, in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that.
Now, let's talk about the February 23rd, 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition, if you care to use that.
36.
Yes, ma'am.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Toros was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone. You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as
intoxicated, right?
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility of the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
What points in time were those?
So she did not remember taking the videos of the suitcase or the incident in the suitcase until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night that, or day or night, that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No,
Well, she didn't indicate to you that she forgot any part of the night, right?
right. She just didn't say that. So
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours, itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? Just yes or no?
No.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So
Okay.
that's what she told me.
She said it was a good day.
Yes.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower.
Right.
And when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad.
And that, in turn, made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you reported her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important
Okay, then explain. Why wouldn't you ask that question?
because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask
be
her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
She never described him doing anything to make her mad, but it was words, correct?
Right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
And you bought that. Okay.
You reviewed the still
You're
photograph,
disqualified from this
of the
court
suitcase, as well
and
as
from
the
ever
video.
trying to help anybody ever
Did you
again.
understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah,
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, She didn't indicate that she let him out, correct?
She did not.
She sure can.
Described to you, Miss Boone being the she, that she was helpful. to
Pull out a
police.
couple 20, she'll do whatever you want.
Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And yet
And
you
when she
bought everything
described
she said.
Getting Mr. Torres out of the suitcase, she described stretching his little legs.
Yes,
And she stated to you there was no fight that day, correct?
that's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable.
Yes.
Correct. And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether, can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Fine. Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
She reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that,
You don't-
Oh, she
you
accepted
didn't
the BS.
contrast to the autopsy
She just wanted a
photographs or
clarification.
report.
Approach.
My God.
You may proceed.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
yes,
She never told you that there was any nudging or poking with the bat when he was outside the suitcase?
Correct.
She indicated that she ended up flipping the suitcase over face down.
that's right.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No,
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
no,
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
of course not. No.
No other questions?
Any redirect examination?
Briefly, Judge.
Yes, sir.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes,
threatening someone's dogs, is that an example of someone using control?
Yes.
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone,
Yes.
a debit card,
Yes.
destroying a home, TVs, putting holes in the wall,
Yes.
not helping pay the rent and other bills?
So I would say that that could be withholding, that could go under coercive control of another person.
I
What
like
about
it.
violating a court order to have no contact with the person?
Yes.
That's all the question.
Failing to pay bills is
That's what it's
asserting
released.
control, but only if you're a man.
As far as the state is concerned.
Mr. Owens? Thank you, Doctor.
If you're a woman, that's the expectation.
Just allow me a moment to pack up.
Collect all your stuff, ma'am. No worries.
Sorry.
No apologies necessary.
Is she done? There we go. Craptacular performance. Now I see why you don't have a private practice. You assume 100% truth of people who come to you with mental issues. Okay. and you wonder why that practice didn't hold up.
Yes.
I don't know anything about it. She's just... Bring back Miss Pearl. She was oblivious, but I liked her. You know she's got good snacks.
Members of the jury, it is 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible. Again, same instruction I've given you before. Please don't conduct any independent investigation or research as the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. We'll bring you back in as promptly as possible. Thank you.
All right.
Let's go ahead and take a recess, a comfort break for any of us, and then we can address any argument with regard to the any other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 4:13.
Yeah.
All right, thank you. We'll be in a short recess.
Well, there, is that better?
Been recognized by the Florida Supreme Court.
Approach.
That's the only thing I got right now. No pictures. All right, no pictures. I'll tell Yesenia. She got bonged.
Our domestic violence division called her and she said she doesn't want to move forward. So she does want contact with the defendant.
Any other priors that you see?
No criminal history, Judge.
Okay, Mr. Fairley, I'm ordering you as a condition of your bond not to have any threatening or harassing contact with this witness. If I find that you do, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Sir.
So I don't know what kind of relationship you have with this person, but if you're someone who's constantly going to fight with this person, be careful. Because remember, it's not what you think as far as threatening or harassing, it's how she perceives. So can conduct in and of itself violate this order? It absolutely can. If I go like this, is that threatening or harassing? It is. And it can land you in jail in a moment's notice. Do you understand?
Sir.
We're going to reset your
Well,
case to give
funny.
you time to hire a lawyer. So I will have you come up here. The other thing you need
It's
to
attempted
understand is there's a
threatening,
protective
harassing.
order that is in place. I would get to know it because if you violate the protective order, the state can and will file additional charges against you. And then it gets ugly really quick. You understand? I will have you come up here. Well, we're going to have you sign a court order for you not to have any threatening or harassing contact. I'm also prohibiting you from having any weapons as well. No guns, knife, nothing. I'll have you sign a receipt and we'll get you out of here to hire a lawyer. All right? Do not leave until you sign our bond conditions. Otherwise, I'll issue a warrant. Please. Can you file no threatening and harassing?
Fernandez.
No weapons.
Page 10.
Which one?
Fernandez on page 10.
Come up. Ms. Hernandez.
Yes, Hernandez. How are you?
Charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please don't say.
On August 18th, 2023, the defendant issued a check for $1,577 as a payment for vehicle registration. The bank returned the check marked, the bank returned the check saying that there were insufficient funds. Complaining witnesses provided a copy of the demand letter sent to the defendant, no response.
Got it. All right. I'm going to find that there's probable cause to go forward with the case. You need a lawyer to represent you in this case. This is a theft by check and it can have dire consequences on your, going forward. We're going to reset your case to give you time to hire a lawyer. So I'm not going to put any conditions on your bond. Just be careful. Don't pick up any new cases. We'll just have you sign a reset and we'll get you out of here. When you come back, please have a lawyer. Okay? Please.
All right, Judge, next is Richardson, 2122.
Is Ramona here?
Yes.
She's hiding from
I was hoping she was going to say it was in her trust.
In spirit.
No such luck.
Yes.
Kendrick Richardson. You are on bond for 2 assaults, and now you've picked up a new case.
Can I explain myself?
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 15th, 2024, officers were assisting with a stranded motorist disabled in Harris County, Texas, when a witness ran up to the officer and stated that he had been shot at. Witness fell on the ground and the officers observed the defendant running across the street. Witness pointed out the defendant and stated defendant was the one who shot him.
What?
Shot at him.
And he's charged with an evading arrest and an aggravated assault with a deadly weapon?
Sure, Judge. I can look further into the offense report.
Your Honor,
but-
on this case, initially, yes, that's what the complainant said, but upon further investigation, the officer could not locate the weapon. And also, he was unsure of whether, based on the officer's report, whether the defendant was the one who shot based on location of the complainant, as well as the fact that he couldn't observe the weapon upon retracing the steps of the defendant.
Don't we have shot spotters out there now anyways? What, I mean,
Come on, he was just walking while black.
you know, I would be interesting to see where this location is, see if there's an actual shot spotter out there. If there is, let's pull the records. You know, it's not rocket science, okay?
So the defendant then began running in the officer's direction. Officers marked patrol vehicle was blocking the lanes with lights activated. Officer yelled at D to stop.
I'm the defendant.
You are the defendant.
Yelled at the defendant to stop and identified himself as police. Defendant turned around and began to run away from the officer. Officer gave chase and yelled again to the defendant, IDing himself and asking for the defendant to stop, which the defendant refused, looking back and continued running. Approximate length of chase was 0.6 miles.
Mr. Richardson, I'm going to find that there's probable cause to go forward with your evading arrest. You have been given multiple bonds. I asked you to do one thing while you were on bond for both of those assault cases. Do you remember?
Stay clean.
And stay out of trouble.
Stay out of trouble. I was shy.
And now you picked up a new case. I'm revoking your bond. He goes with you.
I know. Whenever I do trials, I miss a bunch of good appearances. It's just the way it is.
Revoking my bond?
Mhm.
I was shy.
Bye.
We're gonna look further into the facts.
Please.
You had one job.
All right, who's next?
Judge, that was the last arraignment for
Okay,
now.
ready?
I'm here on Tamara Ely, and I was appointed on Friday.
Custody or bond?
She's on bond.
Ely with a K?
Ely, E-A-L-Y.
Okay.
And I'm still waiting on discovery from the state. It was an older case.
Set it off because, so
we could get discovery, which there is none. I mean,
We re-requested it from HPD, and we have not gotten any response regarding any kind of body cam or dash cam or station video.
we subpoena the officer to come here today?
I'm sorry?
Didn't we subpoena the officer to come here today?
I don't think we did. That might have been a different case that you're thinking of, because we did subpoena an officer about 2 weeks ago. to
Okay,
provide
so let's do
surveillance.
that with this case as well now.
Okay, yes, Judge.
Officer, he's got to be here in a week to provide any and all videos, all evidence in this case, and let him know if he fails to show up, or if he fails to get the evidence, then I'm gonna have a show cause hearing. Okay, so we'll set it off a week. I'm not waiving the appearance. She's got to come back, you know, and then we'll see in a week. Hopefully we can have it by then. Okay, thanks. Hey, Max.
I have two. Renisha Bennett is the last name, first one.
Okay.
So this is one, Judge, where she was charged with a federal offense out of Atlanta. It's like a fraud theft thing. It would be, she was charged after our case was filed, but events occurred prior. She is an attorney in Atlanta.
She's a lawyer too?
No, she's not. No. She has an attorney. in
Okay.
Atlanta. They, right now, it looks like.
She in
the
custody?
No, they've let her out, but the AUSAs there are recommending like 2 years roughly in federal custody. There's some kind of negotiating that, I guess. I don't know all the details.
You guys don't represent her in the
Do
federal?
not, I have nothing to do with it. State is going to kind of like, not eval, but I think we think that maybe the correct resolution to this may be some sort of like a time served or something. I'm gonna ask.
And I'm okay with that.
And I'm gonna reach out to her to make sure she can reach out to them. If like, that needs to be part of their plea negotiation or whatever.
I can't imagine it's a federal case, you know, and it's a different jurisdiction. So, I mean, I'll give you a couple weeks, but she's got to be here at the next setting.
I'll tell her that, that's fine.
Okay.
And we also have Carlos Gomez, Judge.
Give me a second when you're ready.
Yes, sir.
Weeks must appear You said dormant, right?
Yes, sir. So on this one, I think they are gonna have trouble wheeling him. He is in his own driveway by the time police arrive, and it's like he takes a picture from his driveway of like the vehicles. They're gonna reach out. There is potentially a lay witness who is the wheel witness. And so they're gonna reach out to see if that person can actually saw him driving. I don't believe that he did. And so we would just ask for a couple weeks for them to do that.
Sure. In the event that they're able to make the case, what do you want to do? Are you going to set it then? Are you going to?
And I will know, I'll talk with him about it and let him know. I don't think they've looked at that.
In the event that it crumbles, is he approved for PTI?
It's a second,
Yeah.
right?
It happens as a first.
Is it?
Okay, so he was.
Oh, he
yeah,
has
I
one that
think
was dismissed.
That's what it was.
For PT, he already, I
Was it
think.
PTI
completed the
dismissal?
PTI
That's what it
program.
was. Sorry.
Yeah, so he probably.
And I'm
yeah.
not, no, I'm not going to do time served on him.
Okay.
So let him know.
Okay, I'll talk about it. Understood.
Okay. All right, so we'll give you, 2 to 3 weeks.
Okay, that's fine. And he's here too today.
Okay, so, but be ready by next time.
Okay.
Okay, all right. Trial case, guys, are you ready? Tyler, you ready? Okay. Let me see about doing this plea.
Sorted.
Who's your client?
Dominguez, Your Honor. Jose Dominguez. Okay. Let me go get that.
I'll let you translate just because we don't have it, but sign your name on the bottom that you translated. Mr. Dominguez, you
Señor Domínguez, a usted se le acusa
driving while
de manejar
intoxicated,
intoxicado.
facing up to a year in
Usted
jail
enfrenta
and or a
cárcel hasta un año y multa de $4,000.
guys have worked out an agreement. They're
Tenemos
offering
un
you 1
acuerdo
year in jail
que le ofrecen un año en la cárcel,
to be probated for
que
1
le van a
year.
dar probatoria por un año. Mrs. Dominguez.
As part of the probation, you will do a TRAS, which is an evaluation to
Una
see what
evaluación que se llama
conditions
TIRAS
you may
para
need.
ver cuáles otras condiciones usted
Also do
posiblemente
a
necesita.
repeat offender
Vas a
DWI
tomar
education class,
Un clase de droga y alcohol,
one victim impact
un clase
panel,
panel de impacto de víctimas.
have a guardian
Tienes
interlock
que hacer el aparato de soplar
throughout the entire time,
por medio de todo la probatoria.
no breath test
Usted
refusal.
no puede negar la muestra de aliento. Si te
An officer asks you to submit to a breath sample,
te
you
piden
must.
hacer una muestra de aliento, lo tienes que hacer.
No drugs,
No puedes usar drogas, no puedes usar ningún tipo de alcohol.
have now. Does he have a device now?
He doesn't have a device at this moment. No tienes aparato de soplar, ¿verdad? He doesn't have a device right now. Le van a dar 2 semanas,
Must have the device within 2
pero
weeks.
tienes que tener el aparato dentro de 2 semanas.
If not,
Si no lo tienes,
violate any of these conditions,
si violas
in
cualquier
jail.
condición, te van a meter a la cárcel.
Well, I don't know. This feed might be a minute or two behind. I have it on. There we go.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Dave Castro on behalf of the state. William J.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone.
Ms. Boone is seated at council's table wearing the same dark gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Yes.
Yes, sir. Yes, sir.
Yes, Judge, there's two orders that I'm going to be requesting the court to take judicial notice of.
What?
90.202 sub 6. And the orders of no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
Doesn't change my position.
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Doesn't change.
Understood. Okay. You can bring them on up. Thank you, sir. Court has been provided no contact orders issued in case number 2019 MM 5062 on or about June 16, 2019, and a no contact order in case number 2019 MM 5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any argument as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of Regional Director Dr. Harper saying that an element of control is talked about greatly by the state when I point out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing under Mr. Boone. These show that they were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Okay. Response.
So in regards to the judicial notice aspect, we don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we rely upon in making these determinations as an expert about whether there's battered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Moon that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It just that doesn't mean that the paperwork comes in as evidence. So that's our objection: is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself, because it says that the court can take judicial notice. So that's the foundationary part. And it's not hearsay, it's an order of the court. We're in a case where we've gotten evidence of past domestic abuse. There was evidence of it started with the state about control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
But how's it not hearsay? Just because it's a court record, it's still out of court statement.
It is.
Certainly being offered for the truth of the matter asserted.
It's
No contact
hearsay.
order.
Judge, that's why we have the thing that the court could take judicial notice.
You didn't have your witness
The
testify
case law
about it.
says you can't utilize judicial
Tough
notice
nuggets.
to get around hearsay. I know 9202 says that I may take judicial notice. 9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 Southern 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
The way you get this in is you have your expert look at it and you ask him questions about it. And you say, are you aware that we had these TPOs or whatever the hell they are? And does that help form the basis for your opinion? And then they say, yeah, that falls in line with my BS diagnosis. And then boom, there you go. You've got testimony that it happened. That's how this is done. I don't know what they're doing. I don't want to help them.
Yes.
I want her convicted. I want her rung up.
One of the exceptions to the hearsay rule is business records exception. So if it's a business record and it's kept in the normal course of business, then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule. However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that foundation, because the court, under the statute 90.2026, can take judicial notice of court orders. This is a court order, it's certified. I think it's an exception to the hearsay rule. Also, I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, you're right.
Any other argument, state?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body worn cameras, Mr. Torres is like, well, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay. All right. Thank you very much.
Well, I mean, probably it's a low bar.
State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And the court, in relying on the Florida Supreme Court decision in Dufour, Dufour v. State, 69 Southern 3rd, 235 at pinpoint 253 by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order, and the requisite requirements for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things, as required by paragraphs, sections.
Okay, that being no.
These two documents, even though the state is not conceding the procedure for judicial notice, I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
Judge, we do
Through the
have
magic of
four
Woodbridge.
subpoenaed. I don't know where they are. I assume they're somewhere in this building. I believe they sent some message to us back before the hurricane about what they did were to come, and we said to be continued. So we haven't gotten back up with them yet. So
None of this matters much. It's coming in other ways. The prosecutor pointed out.
to check on that, it's 4:30.
Was the subpoena still for this time period?
You can still make that argument in closing arguments
But we haven't followed back up with them.
based on the evidence presented in the
I'll give you an
trial.
opportunity to do that.
That's what matters.
I don't know whether you could just go ahead and send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and if the state has Dr. Werner. It's probably gonna take me a little bit to find.
I'll give you that opportunity. Absolutely.
Right now?
If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes. Third floor? Sure.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's gonna take them to do that, but we could present that in the morning and then rest in the morning, and then they can.
All right, that works for me.
Judge, I'm not gonna make some poor employee come in and do that. I was conceding the authenticity. I don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by.
Stop talking.
Public record and.
Make him bring the damn witness.
I know, but no one's made that argument yet.
They won't do it, and even if it does, it makes them scurry around.
Okay.
My God.
I won't object to them coming in. But
Make them bring their witness.
for other records. We'll see what we do.
Okay.
It's a jag
All
off
right.
move. You
So
make
the
them
state is still
prove it.
maintaining its hearsay objection. I do find that it is relevant.
Good job, prosecutor.
So then what do you want to do, Mr. J?
I'm stipulating to, if the hang up for the court and the defendant is that they believe a clerk of the court needs to come in and testify, I'm conceding that issue so that person does not have to do.
This is court every day.
Okay. All right, fine.
Welcome to
Then
my
based on the
world.
court, on the concession by the defense, or I'm sorry, by the state, excuse me. Do you have any other objections with regard to these two non-contact orders? Mr. J?
No more.
Okay, for the reasons previously articulated, I do find it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite?
Oh my
individual?
God.
Individually.
Okay. Madam Clerk, could you pre-mark them and then we'll
Oh
identify them, please?
my God. Make him drag the witness down. Unbelievable. What happened here? All right, all right. I didn't do that, by the way. That just went down by itself.
The no contact order in 2019 MM 5062 dated June 16, 2019 has been pre-marked as AB. And the no contact order in 19 MM 5114 dated June 19th, 2019 is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her, why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the court, with the defendant. But we do need some time with her.
Okay. All right. So then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow, and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. State, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Werner will take long on our part. I'm not sure how long it'll take on their part. And then there's about.
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
If it's direct is 30, my cross is probably going to be 30.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body worn camera and from the phone extraction.
Mhm.
And then reading a good bit of phone text messages with the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings? Or are we going to proceed with closings Friday morning after had the opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on better spouse that we're going to be requesting.
Okay.
There'll be some, there's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what.
Go to law school, they said.
Is going to be inclined to do if.
It'll be fun, they said.
Be so inclined to give a special instruction on better spouse, whether or not you want to consider one of the local courts, the Palm Beach County case.
Next thing you know, you've been doing this shit for 30 years.
There was a special instruction in that case, and then we've got some from other states. I don't know what the state's position is going to be on that. So we may.
Has a draft of that been circulated yet?
Not to the court.
Okay. All right.
State.
All right. So
Or the state.
here's what we're going to do. Okay. Let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F. With regard to those, the court will have Ms. Barrios email you all. She just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning.
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
Judge?
Yes, sir.
There was one thing. The state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read the motion and the proposed instruction. I have no objection to it.
Okay. All right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements. filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state state, have I read that correctly?
I have no idea why that would be in there.
And defense, you have no objection.
No objection, Judge. And it's my understanding that's going to, it's already the standard instruction.
I guess I just don't understand criminal procedure.
It's just a matter of where y'all want it. So I will add this to the red line to be sent out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am.
a
Again,
question of
I don't
law
want to
that
know
should be
specifics
resolved
of
as far as
anything
I'm
that you or
concerned.
your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am, there's a form instruction. It's 3.9B, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Okay. Let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you.
Okay. Anything else, state, we need to address?
Thank you, Your Honor.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
All right. Well, I've seen enough of that. I've seen enough of that nonsense. Okay, so people are asking, I hate to do it because I know most of you don't care. What I was saying is that they're doing a jury instruction saying, asking the jury as a factual matter, whether or not they think the statements were voluntary. That strikes me as odd, but this is not what I do. So I'm sure they know better than me. Let me just start with that. But it strikes me as insane. You're going to confuse the hell out of a jury. You want to look at the facts, and that's ultimately a conclusion of law. The judge should look at the situation and make the ruling. There should be some sort of motion in limine where you fight about, so our motion to suppress, we want to get these statements out, and then this should all be hashed out before you get to trial. You're asking a bunch of lay people whether or not they think the statements were voluntary, which is truly sort of a constitutional kind of, it doesn't sound like it, but it's layered, and they're going to think they know shit that they don't know. It's just confusing. It's bad. I don't know. I have no idea. This jury, I mean, it should be 10 minutes, but I don't think it will be. I'll tell you what'll make the jury take forever. Sending back a freaking instruction about whether or not they think the statement was voluntary given to the cop. By the way, none of it's required. Just play the damn video she took of herself. Call her a monster and tell them they need to convict. That's it. And then this other sleaze going on. Okay, since we're here, I'll get out of your hair, but this is only for the people who care about the inside baseball shit. Again, I don't do criminal stuff, but it chaps my ass that they're trying to get the judge to take judicial notice of documents at the close of their case. Again, in a civil case, where I do it, the judges would be like, hell no. We had a pretrial conference about this. We had motions in limine. We did jury instructions. We hashed out all this stuff. Everybody, we had an exhibit list. We asked for everything that you planned to offer. Not to mention the fact that the state's put on their case. It changes. If you're going to allow this evidence in, then maybe they need to rebut it. Maybe they need to do something about it. They already put on their case. I guess they have a rebuttal case. But still, that is, any one of their 10 witnesses might have something to say about the evidence that you're now offering to put in. It strikes me as sleazy as hell. And that's when I say, all right, if they don't have hearsay, here's the thing. It's very typical. I guess this is just me. It's very typical. If we're agreeing, I do this, we're headed towards hearing, opposing counsels are saying, I'll let your report in. If you let my report in, okay, fine. I can be a very agreeable guy. But if you cross me, it's time to be a prick. If you don't have that in you, you're going to get run over. You cannot do this. You can't practice like that. Oh, just whatever. I'll just be amenable to bullshit. You want to bring evidence the last time? Get your witness. I want you wasting an hour of your time tonight coordinating a witness and dragging him down here. And I know you're going to get it, and I don't care. And I'm going to make a couple objections while you do it, just to throw you off, just to get in your head. Why? Because you screwed with me. You sandbagged me. You'll feel the pain every time you do that to me. Every single time. You have to understand these attorneys, they're in an environment. It's all the same people. They do this for a decade in a row. You can't get a reputation of being like, oh, just roll over on everything and be super nice. Hell no. I'll be nice if you're being nice. If you want to get nasty, we'll get nasty. Pick a side. I'm better now. By the way, I think the state did great today. I think the defense is doing fine. I think that the state just was. There's another thing, which is, hey, you're way ahead. Just get the thing to the end. The trial's going well. That's the way I perceive it for the state. Like I said, you can always have jury nullification by some weirdo, but any rational person who watched this case is thinking this woman's got to go to jail. Now, we run the risk that there's some irrational people on the jury, absolutely, or maybe there is, maybe there isn't. I don't know. I haven't seen them. But you can also take the tact of, well, it'll be a little faster and a little bit easier, and I already think we're kicking their ass. I'm not that nice. I'm not that nice. You sandbag me, then you waste your time tonight lining up a witness and coming down here. They might not get there. Distract them from their closing. Hell yes, I'm not above that. Match the energy. They do have that issue. She's nasty and unlikable. The only person who's ever believed anything Sarah Boone said was the dippy expert that they hired. And of course she didn't believe anything. She took it at face value so she could get paid. That one didn't seem too bright to me, but she isn't that stupid. She isn't that stupid. She wants to get paid. That was awkward too. Was she sitting there like, well, I tried to have a private practice and I couldn't make that. Yeah, you couldn't make it work. So you go and leech off the government like everybody else. I got it. That was awkward. I don't think she knows how bad that made her look, at least to me. But I'm a cranky old man who just wants everyone to get off his lawn. And I don't even have a lawn. nonetheless, get off it. Okay. All right. Thank you all for coming out. Rant over. We're gonna kick this off fresh, bright and early tomorrow. It's gonna be like I need like a Disney intro with like the birds chirping, you know, and the bunny rabbits, because that's what it's gonna be like tomorrow. We kick this thing off. Thank you all for coming out. I'll see you soon.